State, was there any further evidence from either the defense or the state?
No, Your Honor.
Do you wish to be heard, Mr. Sachs?
Yes, sir. A couple of housekeeping things first. I have a sentencing worksheet since some of these are under structured sentencing showing the defendant with no points, a level 1 offender. We've both Mr. Cutler and I have signed the stipulation for that.
Very well.
The other housekeeping matter I would bring up is with respect to the conspiracy to commit burglary charge that was in 13 CRS 6235, I believe, yes. I would ask the court to either arrest judgment on that one or at the very least consolidate that or run it concurrent with the other matters since he's already been convicted of the conspiracy to commit murder in this matter. I don't want to run afoul of any kind of our case law indicating that there can only be one conspiracy involved in these matters, even though there are different crimes alleged out there. Because obviously with the other charges in there, I just don't think that matters as much. It's not worth the appellate risk is what I'm trying to say of having that out there. So the conspiracy to commit burglary, I'm asking either to run it with other sentences or to arrest the judgment in it, but to sentence on all the other ones. Which brings us obviously to the main point that we're here for, which is about whether or not this court's going to grant this defendant the opportunity to have parole on first-degree murder charges that he's been convicted of. And Your Honor, there's a reason obviously that we put on all the evidence that we did for this case. Obviously, we're looking at the factors that have now been codified in Chapter 15A pursuant to the Supreme Court decision in Miller versus Alabama. That came out a couple of years ago, and looking at those factors to determine what would be an appropriate sentence in this case. And frankly, Your Honor, I think it's very instructive to actually think about the Supreme Court case that led to this relatively new procedure. Yes,
got it right here.
I know, and I did the same thing. I think it's very instructive to see, and you could see what the court's concern was. They were concerned about juveniles having a mandatory sentence when maybe they weren't as culpable or as involved, and you can clearly see they were clearly worried about defendants being either an aider or abettor, or being involved in conspiracy, or especially the felony murder rule, where they intended to do something stupid and a gun got involved by somebody else and somebody died, and then they end up having this mandatory sentence when they didn't intend the killing. I think I counted over 10 or 15 times in that opinion alone. They kept talking about the intent to kill, that the juvenile may not have had the intent to kill in this particular case. Well, this case brings us square into, I guess, either the nightmare scenario or the alternative scenario that the Supreme Court was talking about in this case, because we now have a juvenile who clearly exhibited an intent to kill these victims. It is a transferred intent case, but only between victims. It's not the Supreme Court case talks about felony murder, how that's a transferred intent from intending to do the underlying felony as opposed to the murder. Here we have a clear intent to kill. It's just a transferred intent between victims. Your Honor, that I think in and of itself is reason to impose the sentence that's authorized by both that opinion and by the statute of life without parole. I think when you go through the factors, the only thing that truly absolutely is there is the age of the defendant at the time of the offense. There's just no denying that he was 15 at the time this offense occurred. 2.5, 3 months, whatever, shy of his 16th birthday, but it doesn't matter, even at 16. This is a young defendant committing a very heinous act, but there is no question that this is an intended heinous act. Three of the biggest things are, again, the number of shots that you had in there. It had to be two shooters, but given this defendant, either he shot 29 shots from the AK-47 or he shot 11 from the .45. All of those, all that ammunition they had almost gone out. The statement that you heard that Jacob made to his aunt at the hospital now is important. Now, I think there's evidence that you could say that, because they're going to argue that might have been the person with the pistol because of the motion that he made on there. But think of it the other way. If you believe Moises, which again, he certainly has his problems, but obviously the jury has convicted him this thing, and if Israel did fire that weapon after being startled after coming out, the only one who possibly could have been out of ammunition inside that residence would have been this defendant with the rifle. So if that gun was pointed at Jacob and the trigger pulled and it was the battery had run out or was out on no charge like he was telling his aunts, then that brings up the whole question I brought to the jury as well, that those 2 rounds that were there, that but for the fact of them getting jammed and getting, ejected or somehow cleared from that weapon, could have very well been, the bullets that could have killed Jacob as well. There does not seem to be any filter there or stop there to say, I'm not going to, kill a 3-year-old child, because the child himself said the gun was pointed at him, and the gun was out of its charge. And then the biggest thing is this thing I argued again with the jury with the premeditation. The shots to the back of Maria. This clearly, you're going in with an intent to kill. You are spraying the entire house there with all these bullets between 2 shooters, emptying the clip, shooting behind closed doors in case people are hiding back there. But when you clearly have a woman down in the kitchen who's clearly down, who's clearly not the intended target. There is no question they could, we could argue about, Jose on the couch. I don't think you saw Sancho and you saw the pictures of Jose. They do not look alike, but at least it's another Hispanic male. There's no such excuse for Maria. And Maria's not only down, but she's out. And to come back and to fire at least 5 more shots into her back just shows an innate depravity in this matter that you can't explain by just recklessness, or I didn't know better, or I'm just too young. This is something that is just inside a person. And I don't think that this shows any kind of factor of age being involved in this to do something like that. He can argue the mental health stuff and about his depression and stuff like that. But you notice that what the depression was leading to, 2, maybe even 3 times of an attempted suicide. It wasn't about shooting other people. And all the testimony you heard from his mother was about all these times when the defendant was a victim. Well, how about the month before, in December, when he's now been convicted of doing the shooting on Juan Hernandez, and he's involved in the assault? If nothing else, shouldn't that have been like a warning shot? To know, if I'm young and I'm involved in shootings and I could have been shot at, or had a gun pointed at me and I've been shot at or whatever, and now I've shot, and I've hit somebody, I could have almost killed somebody here. But no, it just keeps escalating. It just keeps escalating, which led to what happened on January 5th of 2013. And there's nothing I would argue from his childhood. I think it's all an explanation. The biggest question is what we hear all the time in regard to sentencing these matters. It's just not an excuse. And I'm not saying not to consider it. I'm just saying it's not enough to overcome the circumstances and the nature of this particular crime, of this particular murder, to show that he deserves any chance at parole for these cases. Remember, we're not talking about one murder. We'd be saying the same things if this was just one homicide. We're talking about 2. He went into a deadbolt, locked house in the middle of the night and killed 2 innocent people in their home in the middle of the night, and some evidence is showing how they would have killed a 3-year-old child, but for the fact that they had no more ammunition. This just shows, I think, just not only that intent to kill, but just that depravity that this is not explained by his upbringing, it's not explained by his youth, this is explained only by him. This is who he is, and these are the choices that he made. And this is the exact polar opposite scenario that they kept talking about in Miller v. Alabama, that if we had something else where it was a clear intent to kill, we might be deciding this differently. Well, here it is. Here it is. This is an intent to kill case if there ever was by a juvenile. And for that reason and for the other reasons that I've cited here, I'm asking the court to impose both life sentences without parole and to give every day we can on those other sentences to run back, except for the conspiracy to commit burglary like I talked about before. And that would be the state's request, Your Honor.
Do you want to say anything about the firearm charge?
The firearm charge, Your Honor, came out in the language as a misdemeanor, even though in the title it was a felony. That was by the language of the indictment, it's a misdemeanor. At most, he can get a class 1 misdemeanor, level 1. At most, he could get 45 days for that. So, frankly, no, that is not the state's bigger concern at this particular point. But the murders, the conspiracy to commit the murder, and the first-degree burglary, and the assault, yes, sir. Those are the state's main concerns.
All right. Mr. Cutler, do you want to be heard on behalf of the defendant?
Yes, Your Honor. Your Honor, I would respectfully disagree with Mr. Sachs' assessment of the case law and obviously what the Supreme Court did in the Miller case, in that it was not just about intent to kill, that was the defining difference. It's about juveniles. It's about young people and how their brains are not developed at the age of 15 years old, that kids subject to pressures and a dangerous environment are going to react in a way that's not necessarily their fault, that they cannot control because of their age. So if we look at the mitigating factors, there's not one that says, well, the defendant didn't intend to kill. I mean, we're talking about first-degree murder. We wouldn't even be going through these factors. You wouldn't be going through these factors if a jury had not said guilty to premeditated murder. This is not a situation where this law was designed to just protect juveniles who maybe not were there or were accessories or were, I mean, the law is clear. If you didn't do those things, no, you don't get life without parole. So what we're talking about is the court said that courts need to consider these mitigating factors and determine whether life without parole is appropriate or whether life with the possibility of parole is appropriate in first-degree premeditated murder cases, the worst kind of cases. Your Honor, if we look at the mitigators, obviously the first one is age, and clearly, you know, that is, Jonathan was 15 at the time of this offense. Just to, you know, the second one that's statutorily listed is immaturity. And Your Honor, you know, what you saw in the trial of Jonathan was from his statement. And I think you can look at that two ways. You can say, well, he may be mature beyond his years from the standpoint of what he's been through, the violence, the things he's seen, the things he's had to basically go into protection mode based on what he's seen, the things he's dealing with his life. But he's not mature by any sense of the imagination. He's immature in a lot of fundamental ways. He's mature in a very sad way, a hardened person who's seen an incredible amount of violence in his lifetime. And that's not the kind of maturity or immature. That factor, you may not say he's immature, but it is sad that the matureness he has is from a bad place. It is from violence that he's seen from, I mean, I think pretty much all the male figures other than his stepfather from his father's side of the family spent their lives in prison for the most part, as far as he knew them. So if we move, and I want to say the court allowed, and it was introduced into evidence, State's Exhibit 14A, which was a notebook, and you can see, and from those lyrics, the rap lyrics that were introduced, you can see someone who is, you can see how much violence he has been subjected to at a young age. He would have been arguably 14, at least according to the date. The one date in that notebook indicates he was 14. And again, this goes back to the influences that he's been subjected to. And the court in Miller talks about those factors. In fact, and I'll get to that in just a minute, but I would suggest to you that a lot of these factors just are with juveniles in general. The ability to appreciate the risk and consequences of their conduct. I certainly don't believe that Jonathan could appreciate or the risks of the behavior that he's been convicted of committing. I don't, you know, you can look, the whole theory of this case from day one has been that this was a mistake. The people that were killed, that was a mistake. There was never an intention to kill, and I mean, not that any victim is either innocent or not. I mean, all victims are probably, none deserve to die. But certainly when you have a mistake, these people were killed accidentally from the standpoint of, they were killed intentionally, but the shooters thought they were someone else. They went there with the intent to retaliate against other gangs. That's the clear motive of this case. The clear motive that came out in this trial for the perpetrators to kill was a beef. There had been back and forth, shootings, fights, fires, different things, but there was clearly a beef between people, and all of the evidence suggested the motive for these killings was a retaliation for gang violence of some sort, or family violence, whatever it may be. It could have been a personal problem that carried over between individuals that turned into a gang violence. But the motive here was never to kill innocent people. And I think it's important that just shows what they're saying here, the ability to appreciate the risk and consequences. Now, whether they went there to kill Sancho or Juan, does that make it any better? Well, certainly it's still murder. But the fact that two innocent victims resulted, I would suggest to the court, certainly makes it much more tragic, but it doesn't make it more heinous from the standpoint of motive and the consequences. This is not a situation where we've seen throughout society where young people go, school shootings, for example, and other acts of domestic terrorism where people intentionally kill innocent people without any regard for who they are and who they're killing. And this isn't that kind of case. This is not the kind of case where a person decided, you know what, I'm going to just go kill people, and I don't care who I kill. You know, we had a case in Wake County, a juvenile case, probably the only other juvenile case that I'm aware of that has been to court and been sentenced since this new law. And that was a juvenile who committed murder, who pled guilty under felony murder, who essentially beat to death, as the facts as I recall them, beat to death a random, essentially somewhat homeless person, a person who was on a greenway, not just minding his own business. And these juveniles, or the juvenile that actually was convicted of the murder and pled guilty, beat this man to death with some kind of, like with a rock. Actually threw a rock over the overpass, struck him, got down, and beat him to death. And there was absolutely no reason to do it other than meanness, other than just to do something. Now, yeah, I'm not suggesting that whatever the motive was in this case, it makes it okay, but it does explain things. It does explain a little bit about why when people are shooting at each other, which is what's going on in this group, the violence between gangs and these people, what you've heard either from the trial, what you've heard from his mother, is this is kind of violence I don't think we even know. I certainly don't have any idea exists out in certain areas and between certain people. And when there's this fighting, shooting, threatening to kill people back and forth, you're going to get to a point where people get killed, people get murdered in retaliation. That doesn't make it right, but at least you can somewhat understand the motive, that there's a reason. And it may be I'm not suggesting it's a good reason, but there is an explanation versus just a random killing for some unknown reason. It appears to just be almost like for the fun of it. And that's not what we have here at all. We clearly have a motive and an intent to kill people, but not the victims. They were the unfortunate, very unfortunate victims of what happened. And there's never been a suggestion that those people were killed knowingly or intentionally because knowing they were not the people they went there to kill. And again, Mr. Sachs, from all the evidence I can glean from the case, Miss Saravia, I believe that's the victim, Maria, was shot in the back. She probably I would suggest they never saw her from the front. They never saw her.
She took one to the
She was
hand.
walking. I contend she was walking and took one right to the hand. Didn't even know. Maybe she was running. Maybe she was trying to get out of there. But I don't think it was a one to the hand, then turn around and take them all in the back. It happened too quick. That shot just happened to miss her back and went through her hand. And that's how I would suggest what happened to her hand. All those shots came with her back turned, and that would explain the shot through the hand if her hand's this way and this. So again, this is not just some random act of violence. From the standpoint of there was a motive, there was a reason that the perpetrators had the intent to kill. But it wasn't, it's never right. That's why you're going to sentence Mr. Santillan to life in prison. You have to sentence him to life. The only question is, will he have the possibility of parole? And you know that. That's the only question, is will he have the possibility of parole? And you can fashion enough sentences that may be, when he may not live to even reach the possibility of parole, depending on how you fashion the judgment. It may be 50, it may be 60, 70 years. But it is important, I think, to consider in any case, and especially in this case, life with the possibility of parole, especially with juveniles. And I think that's what Miller really stands for, is that should be the main goal. Is we don't want to send people to prison, especially juveniles, for the rest of their life where they have no chance and no reason to do better, to be rehabilitated, to be good inmates. Number one, it's disproportionate. A life sentence for a juvenile versus a life sentence for a 40-year-old, that's twice as long. It's twice as long. And you know, you've been around a long time, and you've seen the heinous murders, you've seen death penalty cases, and people who commit multiple murders, they're not all serving, they're not getting the death penalty all the time. They're serving life in prison, the same punishment that Jonathan faces in this case. There are a lot of terrible cases out there where people are serving life without parole. To suggest that this case is worse, somehow worse than all those other cases, I would suggest it is another tragic murder case, first-degree murder case, but the age is an important factor. And if we move on, obviously he has no prior record. That is a mitigating factor that the courts and the legislature has said that needs to be considered. Mental health. Clearly, you've heard evidence that Jonathan suffered from several types of mental health issues, starting with depression and then anxiety and other issues to deal with those with moods. So he's been treated according to the evidence, and he even told the police in his statement, he brought up his father And that apparently was a significant moment in his life when his father became missing and was believed to be kidnapped. He had apparently a bond, and maybe we don't know, maybe we can't understand it, maybe we can, with his biological father. But it was a bond that was created through essentially him seeing him in prison. And again, but he did have that time with him, I believe it was over maybe one summer, where he spent significant time with his father when he was about 8.5, according to his mom, I believe, that they bonded. They got even closer, and that taking his father away from him really started a series of just, it started his downfall from the standpoint of school, and everywhere you turned, he was having trouble. So I think the mental health aspect sort of speaks for itself. I mean, he has been on medication since he's been around 9 years old. You've heard about suicide attempts several suicide attempts that he has attempted at a very young age, after his father became missing. The mitigator number 7, which is familial or peer pressure exerted upon the defendant. This case, I think, speaks to that. This case is not a situation, this is, you heard from Moises, you've heard about Pablo, you've heard about the kind of behavior they're involved, that they're clearly members of gangs, that they clearly have gang disputes with other gangs. To suggest that there was not peer pressure, I think is just, he has older people, Moises, Pablo, both much older than him. Those are the people that apparently he has turned to be friends or to be protectors or whatever it may be. But those are the kind of people that that we know he associated with, at least. And his mother talked about them having an association, albeit it might not have been close, but they were around him for 2 years before this all happened. And we know these folks they're older. You can only imagine that there was pressure, especially, you've heard about the December 4th incident. We still don't know if the jury said that Jonathan fired the shot or if they just believed Jonathan was out there acting in concert with Moises and Pablo that day that Juan was shot in the foot. But that whole scenario suggests who's driving that bus that day. From the evidence, it sounds like Moises was the one he started it. He confronted the people in the car, and then it moved to a fight and then a shooting. But to suggest that there was not pressure there to become involved, pressure to be a part of it, to pull your weight, those types of pressures are inherent in that kind of situation. And then based on what you heard from Moises, based on what you heard from Jonathan, as to why there needed to be these people, why Moises needed to take care of business, because he didn't finish the job the first time. That's the mentality. And it's a sad mentality, but it is a gang mentality. And it is full of pressure. That's what the whole gang life is about, is you've got to pull your weight. And Jonathan being 15, the youngest of all the folks that were involved and mentioned in this case, certainly to suggest there was not pressure exerted, I think is to shut your eyes to that. And I'm not suggesting anybody is saying there was not pressure, but I think it's clear from the evidence. Going back to, the court in Miller and I believe they decided Miller and Jackson jointly. Justice Kagan emphasized that, in this type of sentencing, a judge must be able to consider the characteristics of a juvenile defendant in order to issue a fair and individualized sentence. Adolescence is marked by transient rashness, proclivity for risk, and an inability to assess consequences. And all those are factors that mitigate the punishments, that should mitigate the punishments for juvenile offenders. They pointed out, Justice Kagan in that ruling pointed out that in Alabama and Arkansas, the cases they were referring to, that they erred because a mandatory sentence structure did not take into account the family and home environment, as well as they went on to state that the courts further that juveniles that were currently serving life in prison often were marked by difficult upbringings with frequent exposure to violence. And I think that that's certainly a part of this case, that Jonathan was, from a young age, frequently exposed to violence, saw people actually killed as a young person, and that's something that is, I don't know that we can understand how that can affect. It certainly will have a lasting effect on a person, and a juvenile, to see that kind of violence, it deadens them to it. It makes them afraid. I think it's reasonable. It makes them afraid. It makes them want to protect themselves, and that means you turn to violence. You turn to weapons for protection, and then you turn to violence if that's what you feel needs to happen to be protected and to protect your family and yourself. There is a difference between juveniles and adults. The court, there were briefs, obviously a lot of amicus briefs were done in these cases, and the American Academy of Child and Adolescent Psychiatry, the American Psychological Association, all that research was brought in to bear to suggest basically that juveniles are not. Juveniles' minds and their brains are not fully capable. They're not complete. They're not developed. And that that decisions juveniles make cannot be looked at the same way as those that an adult, with an adult fully developed mind, make. They just should not be looked at the same way. Obviously, the chance for rehabilitation and the likelihood, as the statute says, that rehabilitation may occur is an important factor in all this process. And I would suggest that if we made an error, and I wouldn't necessarily call it an error, but if you err on the side of that maybe there is hope, maybe he can be rehabilitated, maybe one day he will prove himself to the parole commission, and maybe one day he will get out and on parole if you grant him that opportunity at some point, at least the possibility of it. There's nothing to say he will ever get out if you give him the possibility of parole. Certainly, to say that we don't think he has that capability, to me, that would be the erring on the wrong side of the equation. Because if you're right, but you give him the possibility for parole, he'll never get out. He will not be able to conform. He will not be able to comply with the rules and regulations. He will not be able to deal with prison, the violence that's in prison. He will not be a model prisoner if he's not capable of rehabilitation. And so you're risking nothing by giving him that possibility, because if he is depraved, if he is incapable of being rehabilitated, then he will never get out. You must trust our system and the parole commission to say this person should not get out. He's not capable. He's not proven himself. And we're talking a long time from now, potentially, depending on your sentence. It does not have to be 25 years. But I would suggest to the court that giving him that possibility, giving any juvenile under these facts and under these mitigators is not risking anything. It is simply saying, I understand that a juvenile mind is not developed, and I understand there are influences in this world that make people, essentially make people who they are. That if you're subjected to violence from day one, you are gonna likely be a violent person. So I'd ask you to consider all the mitigating factors. One thing I wanted to point out from States 12A, among
14A.
14A, thank you. Among that among the rap lyrics that were introduced, there was, and I think the court even pointed out, there was a writing that's called My Dad. And I just wanted to read that to the court because
That, just for the record, that the jury never saw that part.
that is correct. But it was part of the
Right.
it was part of the exhibit. And so I think it's into evidence.
It isn't.
It was
it's
just
all in
not
evidence.
right. And so I think it just suggests that among all the violence that maybe he had in his head and had been subjected to, he still wrote about his dad, and that his dad, and this is in the same writings. So we're talking about the same time frame that he wrote these rap lyrics. He wrote, or at least this writing was found. My dad, these people think they got it hard. Haven't seen my daddy since 5 years ago. Feels like my heart teared out, beat up, thrown in a hole, and buried. Don't know if he's out there or in the cemetery. That's why my eyes stay dry, wishing I was in the sky. My heart is cold like Frosty, the snowman, and hard like the stones that killed Goliath in the Bible. It's hard to talk to someone because I know they're going to stab me in the throat when I turn my back, when I turn my neck. Waiting for someone who I can trust, and I think that's part of that sentence. Let me restate that. Because I know they're going to stab me in the throat when I turn my neck, waiting for someone who I can trust. Because half the people I mess with would leave me in the dust. So it's a sad commentary on Jonathan's life, right there. A life filled with heartbreak, with violence, with distrust. And I would suggest that is just something to consider, again, in mitigation. That Jonathan there's nothing to suggest that he's not capable of rehabilitation, that he should not have that chance one day, that he shouldn't be given at least hope that if he can work and do everything he needs to do, one day he may get out. There's no guarantee he will ever get out. But to say that he should never get out is a serious, and some would say a cruel punishment for a juvenile. But, Your Honor, I'd ask you to consider the mitigators. I'd ask you to consider, obviously, what our courts, the movement that our courts have made in the development of understanding juveniles and how they shouldn't face the death penalty and shouldn't face life imprisonment. And some states don't even have life imprisonment without parole at all for juveniles. So this is something that's new. It's new to me. It's new to Wake County, new to North Carolina. And I trust you will do the best you can to weigh the mitigators, weigh the facts of this case, and come to a just sentence. Thank you.
I need to take the matter under advisement and draw an order, and I anticipate that's going to take me 30 to 45 minutes. I will re-adjourn no earlier than 12:30, and I think the grand jury is coming too, so if she comes, let me know. And I will let you know what my decision is. The new law, does require the court to make specific findings in the absence or the presence of the mitigating factors that have been offered, and I need to take that and do that before I enter a judgment. So we will be at ease until no earlier than 12:30. I'll try to be back at 12:30, but I'll do the best I can.